We're live.
Good morning. It's February 12th in Senate Judiciary. We're taking up S-183 with a small change, and we're going to discuss that change. And we have Ledge Counsel here with us. The floor is all yours.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and we are taking a look at a committee amendment. It's draft 1.1 dated February 10th at 11:12 a.m. And it's just an individual instance of amendment. You know, I could do a strike vote, but the changes are so small. It seemed as though this would be a little better than having to reproduce the 7 pages, but it's your choice. And so the one change was one that was recommended by the Attorney General's office, and they testified to, and that is with regard to, if you look at the bill as introduced on page 2, subsection B at the bottom of the page, where it talks about, this issue that y'all have been discussing around the person entering the contract or agreement and the requirement that the person has the intent to defraud at that time. And the AG's office brought up the issue of, well, what if there's a change order, right? So they enter into the original and then they say, oh, now we're going to do a little something different to the bathroom than what we had originally contracted for. And so this just accommodates that, so that it would include those, so that the defendant essentially couldn't say, well, I entered in the contract at this point, we did a change order. That kind of negates the issue that they can't use that as a defense, that they changed the order.
So would a change order still technically be a contract?
Yes. Yep. So it's just saying that even if you have whether it's the initial one or you change the conditions, then it's the intent to defraud at that time.
And it would be, okay, so it would be the intent to defraud at the time of entering into the new contract.
Correct.
That this would come.
Yeah. Yeah, so it could be that maybe there wasn't an intent to defraud originally, then there's some changes, and they would go from that point.
So that's lines 18 and 19, Michelle.
Correct.
Striking out contract or agreement and inserting contract or change order.
So I guess this probably would have been a question for Todd, but if a change order is a contract, why would, and a new contract is being entered into a month or a year later, why wouldn't it
Just
still
apply with the current language?
Yeah.
Right. I see your point, and I think, I don't want to speak for them, but I suspect that it's to preclude any argument, to kind of clarify that that would be included, so that somebody couldn't make the argument under just having the existing language with the contract or agreement to make that argument. Okay. So I think it's probably just one for clarity.
Yeah. Any questions or comments?
So I'm just noticing that I just changed it on the first one. That was their recommendation, but I think you should probably, so like the first part of B is that if you enter into these things for $1,000 or more, and then the second piece of it is or aggregated for $2,500.
Oh, yeah.
So so I'm wondering if we should just add that there as well. Maybe it's not needed. Maybe we leave it there, and if you guys vote it out, I'll check with the AG's office if they think it should also.
Yeah, because the latter is plural.
Right.
Versus.
I'm just trying to think about how that would work if you have a variety of clients, right? And so it seems as though it should be the same. I don't know why it would be different. So I could change it now if you wanted to and add that in there.
Well, how is the committee feeling about the amendment? Or is there any opposition?
I don't have a problem with it. So what are you deleting, or where is it starting for the 2,500 or more? Michelle?
So it would be the same kind of thing where you would, let's say with so if you're looking at line 19 with an owner for home improvement or land improvement, we're into several contracts, and then it would just be kind of a repetition of what the amendment says there. So you'd be striking out
2,500?
the contracts or agreements, and then putting in contracts, agreements, or change orders. And I can do that this morning and then just send it there. So if you want to vote for it, or I can send you the language, send the language to Emery, and then you can just vote later this morning.
Yeah, I think if, we'll vote later this morning.
Okay.
When Senator Matos gets here.
And I'll reach out to Todd and just double check with him.
Okay, great.
Okay.
And
Does the amount remain the same, or, I'm sorry,
what was your question?
does the amount remain the same on
Yes.
page 2,500?
Well, that's your choice.
Well, I'm asking, this is
But I'm not
1,000 on
sure.
the other page.
Yeah, she's not changing that.
I'm not changing that.
All right. Just contract agreements for.
Right, so the first one is like if you have one client and it's got to be at least $1,000, but for the other thing that's under existing law is if you had maybe 3 or 4 clients and they had lower amounts, but in the aggregate, a total $2,500 or more.
So,
I have a question about that, and then a broader question. Do you, so, and you may not know the answer, you might not be the right attorney, but years back, we passed a contractor registry, and that had a monetary amount associated with it, I believe. That you had to be on the registry if you were doing X number. Do you have any idea what that amount is? Is it in the bill?
Yes, it's in the existing law.
Perfect.
For the registry. So it's not, I think it's tagged to if you have a conviction, then you go on the registry.
No, so I thought contractors had to register. Not,
Regardless.
yeah,
just
like just
that.
like a contractor registry, not like you did a bad thing
I
registry.
would not, I'm sorry, I would not do the right
Do you know
person.
who would be the right
I
attorney?
mean, I can ask.
Okay.
Yeah, when I reach out to him.
I remember the bill she's referring to, I don't remember the exact language to it, yes, they created a contract registry.
But there was a monetary amount, like if you were working below that amount, you didn't need to be on it.
Yeah.
And I'm just wondering what that monetary amount is. And the reason I'm asking is because I wonder if it makes logical sense to align the two amounts.
Okay, I'll find out for
Okay.
you.
And then my broader question that's not about this amendment or this particular issue is if we ever heard again from the Department of State's Attorneys and Sheriffs and the AG about whether or not it would streamline and speed up the process to move all of this into the sort of consumer protection part of the AG's office. I don't remember, but I also admittedly last week my brain was pretty fuzzy.
So my question there, and I think we discussed this, was these would go to the state attorney's offices to begin with, and would that just delay the process of saying, oh, we will handle this, we won't handle this, we'll go to the AG's office, and if it goes to the AG's office, will it be criminal or civil? It has to be, this one's, we're turning this back to criminal, obviously. Would they
Yeah,
prosecute it as?
this is the criminal statute. The AG has the registry when you've been convicted. I was just looking, and what you're talking about is that residential contractors have to register with OPR if they contract for projects totaling $10,000 or more.
Okay, that's a pretty high bar.
Right, so
I don't think I wanna raise that
So
threshold
that's
that high.
totally
Okay.
separate from the AG when there's a registry
Yeah.
with somebody and where you have to essentially kind of post a security if you've been convicted and they want to make sure that you can make the client whole in case there's a problem.
That must be adopted our government, whole government operation.
I know.
OPR.
And then the issue of, how it's decided between the AG's office and the state's attorney who's going to take the case. I mean, that would be something that you would ask them. My understanding is that the AG's office does not prosecute these cases. They have Well, you would probably want to talk to them.
Yeah. Just when I think about streamlining the process, it logically makes sense to me, though I know our system isn't always logical, that having it clear that it just goes to the AG's office would, especially, you know, with the backlogs and having no back and forth who's going to do it, to me, that would make it go faster. But I don't know.
Another simple bill.
Well, I mean, I think that's part of your larger, you know, discussion around who takes which cases, right? And I don't know whether or not if the AG was going to do it, you know, their criminal division is, I think, only like 5 or 6 attorneys. And so they work selectively on, you know, like the ICAC stuff, the internet, you know, crimes against children. They do some of the things where there's conflicts in a particular county, but I'm sure you could have Todd in here to talk to you more about those things. You know, if you had it with the AG's office, it's still going to have to be filed in whatever county that the offense occurred in. So
This is probably a question for one of our witnesses that is in later on a different bill, but do you have any sense of how many of these cases there are in a year? I mean, are there 10? Are there 1,000?
Again, I think you probably want to maybe check with Kim McManus on that, because I think that the state's attorneys are the ones who are primarily prosecuting those, but I think it's substantially higher than that. I feel like I, at some point, had heard that there were, you know, dozens of current pending cases.
Because I would just imagine, given the backlogs, that these would probably not, in the state's attorney's triage, would not be the ones they do first. So they probably sit for quite a while currently, but I guess that's why I sort of had the broader question of, you know, did we ever get the folks needed in to answer those questions? It sounds like we did not.
Well, we did. If you have an amendment and witnesses you want to bring in, then, you know, let us know.
Okay.
Do you have an amendment that you want to make to the bill?
I mean, not prepared, but I can certainly get something.
Okay. So we won't vote on it today then. Please let council know what you'd like to change and what witnesses you want back in, or whatever you want to change. And then we can bring it back up either tomorrow or next week.
Okay, I will make the change to the aggregate piece, and I'll send that amendment to Emery to share with you guys, so you'll have that, and then whenever it comes back up, I'll be joining you.
Thank you.
Okay.
That's great up here, Dustin.
You can stay.
Thank you. It's kind of spilled.
Metastasized.
It's all in chronological order, don't worry.
I can't find the attendant.
There you go.
So we're switching gears to S-193. We have Jared from Bennington State's Attorney's here with us in lieu of Kim, I'm assuming, right?
That's right.
Okay, great. So you want to join us? We can get started a bit earlier.
Is there a safer place to plug in my laptop or to show this trail behind here?
That's probably.
We, at one point, had a power strip under the table, but we do not anymore.
I just don't want to.
Actually, maybe we do.
Battery's not great.
Does not look like it.
My apologies, everybody. Good morning.
And you needed a link for
If I may.
right there.
Yes.
You mind sending him that, please?
Let me know if you need my email address.
assume, is it at Vermont.gov?
Yes, it is. But I see on the schedule, my name's a little bit misspelled, so it's JARED.BIANCHI.
Okay.
So, yeah. Should I join with audio?
No.
I'll join.
She's an attorney. Is she what? An attorney or a lobbyist? A lobbyist. I don't know if she's also an attorney. Patty Conroy? She's not an attorney.
No, I don't think so.
Yeah. Long time, housewife. Yeah. Well, I just met one of the attorneys down Barclay Martin at the gym the other night. I guess, anyway, long story short, she knows her.
Mm-hmm.
Thus the question.
Is that okay for everybody? Yep, that works. And just for the record, introduce yourself and then floor is all yours. And good morning, Mr. Chairman, Senators. Appreciate you giving me the time to talk to you today. My name is Jared Bianchi. I am a Deputy State's Attorney in Bennington County, here testifying for the State's Attorneys and Sheriff about S-193. Just a little bit of background. So as to explain what I'm doing here, instead of again, I'm currently a prosecutor in Bennington County. My caseload does include serious felonies and serious felonies with competency or sanity issues where they present. Prior to my present role in Bennington County, I spent more than a decade with the Attorney General's Office representing the Agency of Human Services and all of its constituent departments in administrative litigation and in state and federal trial and appellate courts. So I've been involved in litigating these issues in various capacities for the entirety of my career. In that role, I was also previously responsible for all Act 248 public guardianship matters, and I've also served on various legislative and judiciary study committees touching on competency, sanity, and the forensic process. So the first thing I wanted to touch on is just the need for some kind of forensic system of care. I think sometimes we almost get used to seeing the headlines, but here are just a sampling of stories from around the state on a more recent basis. This issue, competency and sanity, arise in every single county in the state. They are the most serious cases. They require the most serious attention. And although the numbers themselves are small, the impact is enormous on victims, on defendants, on prosecutors, defense attorneys' offices. I'll note that the state's attorney in every county and the sheriffs in every county support this bill. So just to clarify around some concepts as we're talking here, competency, and the quote there will speak for itself, but competency has to do with the defendant's ability in a given moment to engage with the trial process, to talk with his attorney, his or her attorney, to aid in their own defense.
whereas sanity is something that attaches at the time the offense occurs. It's whether or not the person was insane at the time they did the act that they're alleged to have done. So they are related but very distinct concepts, and the process that attends to each of them, one pre-trial, one post-trial, are very different.
Senator Norris?
Yeah, if you could just back up. This just strikes me, a defendant may be sane at the time of the offense, but incompetent to stay in trial, I understand that. Or he may be, or she may be competent to stay in trial, but insane at the time of the offense. Just kind of, what does that mean exactly?
So,
the second portion of it.
The really standard example of that is, a person might be experiencing a mental health crisis at the time that they engage in a particular offense. However, whatever has brought that on has been treated in the meantime. And so while they may have been insane at the time they committed the crime, they are now stabilized such that they can engage in the trial process.
Oh, so they're now stable, okay.
Yeah. There's also other, to give you an example on the other side of things, a person can never have had any sort of mental health crisis and can, on the second day of trial, fall and hit their head on the steps. And if they have some sort of brain injury for however long they need to deal with that, they would then be incompetent. It can arise at any time and it can go away.
Okay, thank you.
Not guilty by reason of insanity. There's a statute that requires this to be done by a jury. I've got here this block quote at the top. That's the model jury instructions on the insanity defense. And what I really want the committee to notice about this is that before a jury ever considers an insanity verdict, the unanimous jury must first find that the state has proven all of the elements of the crime charged beyond a reasonable doubt. So when a person is found not guilty by reason of insanity, the state has carried its burden on all of the elements of the offense. That is different from other types of defenses. It is a very specific thing, and it's a special jury form. And this makes very clear that if you have not satisfied all of those elements, you don't even get to sanity because the state hasn't carried its burden. It also means, though, that the person who's acquitted by reason of insanity has been proven to have committed action that they are alleged to have committed. Competency is different. This is the legal standard. It's reflecting the well-worn standard from U.S. Supreme Court as well as state Supreme Court. And it's a rational understanding of the proceedings as well as the ability to consult with an attorney. And that's a fluid concept. And that's why you'll see some conversation about competency restoration. Sanity is locked in at the time of the crime. Competency is not. But this is actually something that defendants have understood themselves. To hear it explained by one defendant.
When I sit here and tell you how I was talk to a law officer being criminal, I'm a murderer, it's too bad, I don't care what anybody says. People better fucking believe it. If you don't believe it, just go to a psychiatrist and get some help, and you just gotta, tell them, there's no murder investigations in the state of Vermont, they have no evidence, they have no quantities of any structured activity, there's one, being based on a murder, there's no obligations and there's no request of being a murder in the state of Vermont. They have to have trial, they have to have mandated paperwork, that's just, that's just how it is. And, if they don't have the paperwork, then it's an accepted law in Vermont, they can't, because they don't have any criteria, they don't have any database to being a murderer, being convicted of a murder,
So perhaps not in the technical terms that the judiciary might do, but that was posted, and soon thereafter, this defendant was charged with murdering a woman in the middle of downtown Bennington in broad daylight. We, at a certain point, hired an out-of-state evaluator who spoke to this defendant. And after an initial conversation, she expressed that he believed that basically if he were found incompetent, that he would simply be released from prison. And she, being from out of state, felt that that could be a sign that he didn't understand the nature of the proceedings against him. However, he was right, and that's what had happened to him a previous time he was charged with a crime and found not competent for an assaultive charge, a serious assaultive charge. So in that instance, what sounded like something that was beyond the pale to this out-of-state evaluator, he was correct. Turning,
Was he found incompetent on the murder charge as well?
that is, yes, we have been through a couple of rounds of this.
Okay.
So that's ongoing. And he is being reevaluated by evaluators as part of that process now.
And was he released?
He is held right now without bail.
Okay, so he
He's
was
incarcerated
found incompetent.
and a previous charge.
Okay, so he's still being evaluated on this charge.
That's correct.
Okay, but he is not out roaming. He is.
He is
still
not
held.
out roaming. He is
Okay.
still held. That is correct. The way that the process works right now is we're going to have to finish all the evaluations. And when that occurs, then we'll have the hearing that will decide whether he can, what happens to him.
But it's not just a foregone conclusion that someone's found incompetent. And
That's
let
right.
go.
And that's a really important point, Senator. The competency process, although it requires an evaluator, that is a legal determination that the court makes. So there is nothing that is a foregone conclusion, even if the evaluators come forward with a competent or not competent determination. That's subject to an evidentiary hearing in front of the judge, and the judge is the one that makes that decision.
And then ultimately would also make the decision if found incompetent, if they can be released.
That's right.
Not just like, oh, you were found incompetent, see you later.
That is generally true.
Okay.
You know, as with a lot of things, there can be permutations, but yes, that is it. So just in terms of the structure of the bill, Section 1 talks about competency restoration, and it does so within the confines of a forensic facility. The purpose of this is to provide for a restorative process in an appropriate setting so that the person can access the process that is due to them. The need for this process is especially deep in cases like this, where a person might experience a lack of competency and then, for instance, be hospitalized for a period, become stabilized, and then perhaps return to a facility or another setting where they're not able to maintain that competency. Section 2, this talks about dismissal of misdemeanors after 2 years, and this was included because it is based on the structure that is present in some other jurisdictions where misdemeanor cases that have remained inactive for a period equal to what the potential incarceration could have been, and if they remain inactive for that period, they end up being dismissed. And that seemed appropriate, especially in the current structure where if a person is found not competent, oftentimes conditions of release can stay in place. You don't necessarily need or want conditions of release to stay in place for a person for year after year after year, especially if there's not really any intention of trying the case and getting to a conclusion. So this is an appropriate sort of way to address that population of cases where after that period of time, they probably won't be addressed at all. Section 3, that speaks to placement in a forensic facility after an insanity verdict. As we talked about, that's occurring afterward, after a trial, in a case where otherwise there would be a life sentence. I'll note that although it is initially a placement, there are periodic reviews, and there are also mechanisms for supervised release to the community if that person is appropriate for that.
So this is an aspect I'm really confused about. I'm a little confused about how it is constitutional to hold someone who has been found not guilty.
Mm-hmm. And so I would distinguish this from incarceration. This is a public safety-based civil commitment for an extremely small population And the structure of this bill is actually based on the federal statute that does the same thing.
But we're talking about putting this in a prison, so I don't see how it is different than incarceration. We are still putting someone in prison who has been found not guilty.
And that would be probably a better question for the operational folks about settings. Certainly, you can have a person maintained in a secure facility for public safety and other needs, public safety, mental health needs.
Yes.
The propriety of a given building, for instance, that's a little outside my wheelhouse, and I would defer to DOC. I would note, though, that there is, and I think this is required by due process, there is a periodic review that is triggered by the state. So the state would have the responsibility of triggering judicial review. There is a 5-year outside time limit on that, but it's not required to be 5 years if folks at the facility believe that the person should have an earlier review. In either of those circumstances, the state would have the burden of bringing that person in front of the judge. The expectation would be that that person would then have counsel who could make the case for release on conditions. These cases are already cases that are subject to what we call a section 7553 hold pretrial. And so there's a presumption in those cases that the person would be held pretrial unless they carry the burden of showing that it's an extraordinary case that warrants release. Much like that structured pretrial here, where the person has been proven beyond a reasonable doubt to have engaged in the conduct, as distinct from being convicted of a crime, but having engaged in, we're really talking about rape, murder, kidnapping is generally the population of crimes we're talking about. That the state has already carried that heaviest legal burden. And as happens pre-trial now, the defense frequently comes forward with a plan for release. Here's how we think this person can be safe in the community. And it follows on that. Again, that is based on the federal statute. Section 5, that's rulemaking authority. Not much to explain there. And Section 6, this would, for folks who are released on supervised status, this essentially just mirrors the probation process to address any concerns that arise while they're on the status. So what kinds of cases are we talking about in this bill? We are talking about life offenses. In Vermont, these generally consist of murder, rape, kidnapping. These are a small number of cases with a large impact on the community. And who would this impact in terms of defendants? It would be any person who's not competent or who's been adjudicated insane in a case carrying a potential life sentence. There are no diagnostic criteria. I know that you've heard a lot of testimony about hospital level of care. This is a sub-hospital level of care. And you'll see that the structure, we've actually provided some clarifying updates to make clear that a person who needs hospital level of care should be receiving that in, for instance, BPCH. This is not in lieu of that higher level of care for those people who require it. But there are no diagnostic criteria, and this allows a person-specific approach to security, care, and competency restoration. Just by way of example, I've had a case where a person was not competent because they were hard of hearing, but they were also not very good at American Sign Language. And that arose in a not very serious case, but I use that as an example to sort of get away from the, it's all mental health, it's all medication, the ways that competency restoration based on a person's specific need can really be used to accommodate that person to access the process that's due to them. The bill is based on, as I said, the general structure of the federal statute on the topic. It also takes from other states, which have had misdemeanor dismissals after a period of inactivity. And I think that will help to address some of the backlog that you talked about with other bills. Why do we want to restore competency? Because the defendants in these cases have been accused of very serious crimes. The public at large have experienced trauma themselves, and this allows people accused of these most serious crimes to receive those accommodations so that they can access the process that's due to them and put the state to its burden. Nothing about this relieves the state of its burden ultimately of proving the allegations that is brought forward. And I think I've talked about this a little bit, but why does the bill presume that the person goes into a forensic facility at that juncture? And the point is a procedural one, because when a person's found by a jury to have been insane, the state has already carried the burden of proving to a unanimous jury beyond a reasonable doubt that the person did engage in an act carrying a possible life sentence, i.e. murder, rape, and kidnapping. And at that point, the burden properly shifts to that person to demonstrate that they don't present that risk to the public and that they can be out of conditions. And here I've just copied the federal statute that it's modeled on, and you can see the burden of proof for cases, for a broader swath of cases, frankly, than this bill addresses, but substantial injury cases as well. It does have that burden on the person at a higher level, whereas lesser cases, less serious charges have a slightly different lower burden for that person to reach. Some brief points, just based on some of the prior questions and testimony that I've seen. This issue has already been the subject of numerous studies and years of discussion, and this bill is narrowly tailored to address a very small sliver of the most serious cases, where I think that the need is so acute and so high that if we can address them, this will not address aggravated assaults, lewd lascivious conduct of a child. Other serious felonies still will fall outside of what this bill accomplishes. But again, for your murders, rapes, kidnappings, at the very least that gap would be addressed. We heard some testimony about the U.S. Supreme Court case. That's already the law, and it doesn't need to be codified into the statute. The concern about codifying case law into statute is that if another case clarifies the previous decision, you then have to come back and either ignore the statute or amend it, which takes committee time. And the judges on the cases, the attorneys on the cases, are responsible for applying the constitutional laws handed down by the High Court of the country. So that not being in statute would not remove the burden of sale from the matter. Just to be clear, I think that there were some questions around, how long could the competency restoration process take? And I think that is a really person-specific question. I think disputes over that between defendants and prosecutors. There's a mechanism in the criminal rules that already is able to address that. And that's a Rule 48 motion to dismiss in the interest of justice. And that's when you would have a judge look at the particular facts and particular circumstances and the likelihood of circumstances changing and addressing whether or not the case can proceed or not. The review periods, those balance, you have to keep in mind in the cases specifically addressed by this bill, these life defense cases, balancing that victim impact of bringing this back up for review, but it also provides due process that's required for the defendant, as well as the flexibility to use a shorter time period based on what the evaluators say. Senator Bajowski, I know that you had a question about confidentiality in this bill, and so to be clear, this would only, and this is currently the case, so this doesn't actually modify any expectations for confidentiality of records. The records are not public records, and they would go to the parties in the case, and those parties are just the state defendant. So it doesn't provide them to victims or members of the press or anything like that. And they should remain confidential essentially until they're, if they are utilized in a court hearing by either party. But that is, it doesn't make them generally available or to even people who are not the attorneys in the case. I know that you might hear some folks suggest that Section 2, the dismissals be without prejudice. We're agnostic on that suggestion. We have no problem with that recommendation or the way that it's currently drafted. And I would just urge you,
Jared,
yeah.
Can you just, for the committee, can you remind the committee what it means when a case is dismissed with or without prejudice?
Yeah, so when a case is dismissed with prejudice, it means that it can't be refiled. That is a final dismissal of the case. If it's dismissed without prejudice, it means that at another time, the state can refile it if they think that's appropriate. I think there's a lot of really good reasons why it's appropriate to have it be without prejudice. However, we leave it to the committee. And finally, I know that at least in prior iterations of the conversation around forensic process, we hear a lot of, if you build it, they will come, and we would urge you to not adopt that line of thinking. These cases already exist. They're already impacting people, defendants as well as victims in every county in the state, and not addressing them appropriately doesn't make them go away. We have to address this, and we hope that this is sufficiently narrowly tailored to the most serious cases that this will be an answer. We have provided to Attorney Fitzpatrick some edits, which I'm happy to discuss if you want or not. They are done in conjunction with, I know Lori Fisher testified and said she was going to suggest something. I believe I've incorporated that. And then there's just some clarifying language to try to avoid the need for confusion later on.
Do you have the suggested edits?
Yep.
In your PowerPoint? Okay.
They're not, I can change them. I've got to change my, I apologize.
Yeah, I think that we can hear about the suggested edits. I also had some other questions regarding other suggested edits that we've gotten. And tomorrow, I believe we're hearing from Ledge Council, and we can hear their take on the edits if they're available.
Sure. So previously the draft had said deemed a person in need of treatment. I in reviewing this, seemed like it could cause confusion because that could also be a consideration for order of non-hospitalization. So just to clarify that we're talking about a person currently receiving inpatient treatment for an order of hospitalization would be the population carved out. That's just to clarify and not use that other term of art.
Is that a narrower group of people than the language currently in the bill, or a wider group of people?
It's supposed to be the same group as was intended when that was put in. But in rereading the definition and how the courts apply person in need of treatment, I think that there was concern, and I specifically have concern that it might be unclear that we were talking about the people who need hospitalization as a person in need of treatment, not just some mental health treatment.
Okay, so this clarifies to get to that narrow group, whereas this language could have been interpreted to be a much broader group.
That's right.
Okay, thanks.
The next piece is here in the forensic facility for persons acquitted due to reason of insanity. This is really just seeking to more closely align it with the federal statute that I had up on the screen earlier, to take more of the language from the federal model. So again, not supposed to be a substantive change so much as just clarifying language and talking with other stakeholders, and in particular, Attorney Padula wanted to clarify that we really are trying to follow that federal structure. And then this is in consultation with Attorney Fisher. The Department of Corrections was concerned about a circumstance where they're responsible for supervising a person in the community, but then also have the burden of establishing a violation of that supervision in court. And so in our conversations, we agreed that it would be more appropriate in the same way that we do now for probation violations, that the state's attorney would be the person with the responsibility to put the case on and have the burden of proof, instead of the department themselves having it. It seemed like it would muddy the roles a little bit otherwise. So in those conversations, that's why we have this edit. And finally, I just added a definition of forensic facility because it occurred to me we never actually defined the term. So here it's a secure facility or placement for physical placement, allowing for secure evaluation, treatment, and care of individuals involved in the legal system.
Can I just ask a very small question? Do you intend the hyphen before evaluation?
No, I think that's actually a track changes.
Okay.
It's showing a deletion of a space.
I see.
Would that definition, and this may be a better question for our legislative council, but you're sitting here. So with that definition as you proposed it, could that be construed to actually bring in people who are currently being treated at the state hospital?
No. I don't believe so, or at least that's certainly not the intention. I think to address any concern, and I'm happy to make this change essentially right now and send it back to Eric, but we could just say who do not require a hospitalization level of care.
Okay.
And I think that's a fair point. So would have no problem, involved in the legal system who do not require a hospitalization level of care might be an appropriate way to clarify.
Okay. Yeah, it just, as I read it, I was like, that feels like it might suck in folks. So I appreciate that. Thanks.
And are there any other questions?
No, not on these suggestions here. I did have one regarding a suggestion from AHS. The question about diversion and misdemeanors. Were you able to see that suggestion?
I was able to look at that.
Can you just share your thoughts on that?
My initial thought is I think because this is such a narrowly tailored piece of legislation to address a specific need, and because that is not an issue that I think has been sort of really vetted in the way that this one has and developed over time, that perhaps attaching that to this piece of legislation isn't the best path forward. I think because of the scope of the proposal, it would need a lot of looking at to see what kinds of cases are we sweeping into that, for instance, because, as it's currently drafted, it would be all misdemeanors. Misdemeanors include domestic assaults, stalking cases, DUI 2s. There's also a question about whether a person who people are concerned can't be present and engage with a trial where they don't have to speak, they don't have to testify necessarily, although they have the right, whether the more restorative process that they would typically go through for diversion is the best plan to address that population. And finally, a person who may not be competent for diversion, but still can't be tried for an offense. And so I think all of those issues really need to be fleshed out, and I'm not sure that that's necessary to addressing the issue of this bill.
Thank you. That's actually all I have for now. Committee, any other questions or comments? Anything else from you here?
No, thank you all in any way that I can be of service to the committee. I'm happy to.
Thank you. Appreciate your time. Next up, we have Judge Zone.
Good morning.
Morning. Good to see you in person.
Good to be here. Not moving as quickly as I had in years past, but we'll get there. So Tom Zone, Chief Superior Judge. You previously mentioned the question about the U.S. Supreme Court case. In Jackson v. Indiana, the U.S. Supreme Court held that a person charged by a state with a criminal offense who is committed solely on account of his incapacity to proceed to trial cannot be held more than a reasonable period of time necessary to determine whether there is a substantial probability that he will attain that capacity in the foreseeable future. The court further set forth that if restoration was not achieved within a reasonable time, quote, the state must either institute the customary civil commitment proceeding that would be required to commit indefinitely as any other citizen, or release the defendant. And I start with that because I can't comment on a lot of this bill, because there is little doubt that the questions that the court has put out, what is reasonable, and the procedures that are adopted will one day be, it's highly likely they'll be challenged. Is 6 months, is 9 months. And so as far as giving any testimony about the bill looks, you should do X, Y, or Z, or put this time frame in or that, it's a matter that will come before the courts. It is happening in the country. And so the policy decision as to whether to develop this is one that certainly has been made in other states. It sounds like the bill has been put together in an effort to try to address the concerns that give rise to it, as well as to address constitutional concerns and have those issues for the courts to address. But there's not a lot I can say there. One thing I was going to comment on was
and I saw Mr. Bianchi had made some requested changes to the provision about someone who's found not guilty by reason of insanity. The bill says if someone's acquitted, a person who has been acquitted of an offense punishable by, and that's on page 4, line 7. I like the language that Mr. Bianchi used about found not guilty by reason of insanity, because this would suggest that if a jury found they didn't do it, even without the insanity, that they can still be committed. So you want to make it very clear that it's only with what we would phrase the NGRI.
Senator Osteen?
I'm not going to ask you to weigh in on the language of the bill, because your reason for not doing that seems really valid. What I am curious about is if there is any existing or developing case law around what is reasonable and sort of the aspects of the bill. You know, I know you said that this has been done in other states, is being challenged. So is there case law?
There is case law from throughout the country that the court would look at, and legislatures are can make changes depending on that. Some states have set numbers, they have timeframes. Other states have different types of structures. But yes, the short answer is there is case law, which would certainly be available for the Supreme Court of Vermont and any judge of Vermont to use as far as being persuasive. It's not binding unless it's the U.S. Supreme Court.
And there's no U.S. Supreme Court case law on this issue, other than the one you just.
Well, there's other case law, but it's fact-driven.
Okay.
Because you have to find the reasonably or probability and things like that. So the court has to look at the specific facts, and it's not something you can say it's a one-size-fits-all. It's okay, you put these facts in, you weigh them out, and then how does it come out? So there's factors, considerations.
Is there any specific relevant case law that the committee should look at in making any of these decisions?
I cannot say that I have done the research such that I could say, look at X, Y, and Z cases. I think that the state may have cases they think you should look at. The defense may have ones they think you should look at. Mental health, DMH may have one. So.
Okay, that is good information.
Any further testimony?
Again, it's a policy decision, and I mean, certainly it is. There are individuals who would fit this category. That currently there is no structure in place for the program of competency restoration, and so it's something that I'm aware the legislature's been looking at again, like other states.
Do you know roughly how many individuals would fit this?
I don't know the answer to that.
Okay.
Off the top of my head, I'm sorry.
The state's attorneys know.
For the record, Department of State's Attorneys and Sheriffs, when we've looked at the last few years, the average that would fall into this category is about 4 or 5 at any given time. I mean, that could range a little bit, but at any, it's a small subset.
Well, and I will comment that if you would have said, take a guess, I would have said, my guess is 4 or 5. So, nice. It's consistent.
All right. I generally try not to ask people to just take a guess on
No, I know that. That's why, but that would seem consistent with what would be out there.
Committee, any questions for that?
Thank you.
Well, thank you. Yeah.
Have a great day.
Yeah, you as well.
Did you get injured?
I got a new knee.
Oh, you did?
Yeah, and so I hope to shed that within the next couple days, and we're getting back.
Good.
Yeah, and once I hit my range of motion, so now I can shave. That was the motivating factor. So we're good. Have a good day.
Yeah.
So committee, we have a couple of minutes, and we'll get a break in probably before 10:15. But what are the general thoughts, feelings about this bill?
I don't know that my thoughts and feelings about this bill are fully baked or developed yet.
Okay.
I do want to talk to Judge real quick, so.
It does seem narrowly tailored. Obviously, it should be. So, in the absence of any testimony that points out a danger to what's happening here, it seems a rational approach.
was. And looking at the bill from a little bit of testimony we have taken, I'm certainly in support of a forensic facility system, now we're not talking about how we get there, what the costs are gonna, and the cost should really come into play because it's a much needed, facility within the state of Vermont, so I'm liking what I've heard the testimony so far, and hopefully by the time we hear from everybody here, we'll have made up, our minds as to which direction we should go in.
And you're the one that's gotta come up with the money.
Just on a separate note, I just remembered, Emery, can you please reach out to DGS? Have them, see if they're available Thursday at 9 a.m. Some testimony about the contracts. Please. All right, so I know we're also gonna get the suggested edits to Ledge Council, and I'm gonna meet with them tomorrow to go over those, and then we'll get a new copy of the bill. And then we can do another walkthrough. There were also the suggested edits from AHS. I'm inclined to remove or to not add the diversion piece. Though I'm curious your thoughts, if you have any, on the additional proposed changes from AHS. And I think we're also hearing from Karen Barber tomorrow, actually.
Why, because I had asked a question about the diversion piece and why are you inclined not to include the diversion piece?
Largely based on what Jared had described 2 minutes ago, just with how the scope of the forensic facility bill is quite narrow, to the point of 4 or 5 people, whereas the diversion piece is quite broad in scope and would apply to all misdemeanor cases. I don't know that it is, that given the amount of work that we have to do to make sure all the other pieces of this bill, the narrow parts of the bill, are feasible, if we'll be able to really get into all of the weeds of the misdemeanor diversion section. I mean, if there are other perspectives, I'm happy to be proven wrong and add it, but that's my initial take on it. All right. Well, from that note, I guess anything else? Okay. All right, so we can pause until 10.